So continuing the theme of the conference about regeneration and how you take a site from derelict through dispute at this stage, we're going to now look at clearing the title of properties, covenants, problematic covenants, and addressing access. As we all know, one of the most challenging aspects of any development is removing and resolving issues presented by restrictive covenants and troublesome rights of way. In this session, my colleagues Andrew Bruce and Lara Kuehl will now expertly guide you through the recent case law from the Upper Tribunal and the Courts and tackle some effective strategies for developers and objectors. So over to you.
Thank you very much indeed. What Lara and I are going to be doing in our session is trying to address what I've termed on the introduction slide as the developer's dilemma. So that's a situation where planning permission has been granted, whether it's for the conversion of an office block into a mixed-use property, whether it's for a residential development of a brownfield site, or whether it's simply a new house in the garden of an existing house. But at that planning stage, the objectors, neighbours, have objected to the planning and have referred to their own private law rights. And they say, in respect of each of these proposed developments, that there should be no conversion of the office block because there was a restrictive covenant limiting it to B1 office use. Or there should be no residential development on that brownfield site because there's a covenant that limits the number of houses on the plot to no more than 4. Or there should be no new house in the back garden because there's a prohibition preventing use other than as a rear garden. Oh, and incidentally, they say, in relation to the rear garden development, that garden has use of an access way, but only in connection with its use as a garden. So what Lara and I are going to do today is try and explain what the developer might do in that situation. And we're going to take you to Section 84 of the Law of Property Act 1925. So that is our century-old piece of legislation. Lara will talk first of all about looking at Section 84.2 to establish the existence, the construction, and the enforceability of that covenant. And then I'm going to look at Section 84.1, which permits the Upper Tribunal to modify or discharge that covenant. And I'm also going to take us and see whether that section also allows us to deal with modification of easements. So Lara's going to deal with 84.2 and declarations under that first of all.
Thank you, Andrew. So although Section 84.2 comes second numerically, obviously it logically comes first in terms of considering what to do, because the developer may not necessarily accept that the covenant is applicable, actually applies to their land, actually applies to what they're going to do, is enforceable, and it may not actually be known whether there is in fact anyone who is capable of enforcing the covenant. So a starting point might be an appropriate case if it's not obvious that those things should, that there is, if it's not obvious that there is a relevant restrictive covenant, one might consider seeking a declaration from the court under Section 84.2, which is set out. It allows any interested party to apply to the court for a declaration as to the nature and extent of a covenant and whether it is enforceable or would be in any given event enforceable and by whom. In an appropriate case, a declaration under Section 84.2 can be a brilliant solution because unlike the usual position where you seek a declaration from the court, which would only usually be binding on the parties to the proceedings, the named parties, under an application under Section 84(2), if successful, will give you a declaration that would be binding against all persons who are entitled to or capable of becoming entitled at some point to the restriction, whether or not they have in fact been served with notice, whether or not they were parties to the proceedings, and whether or not they were entitled to the benefit at the time of the application. So it's effectively binding in rem. And then that is incredibly useful, obviously, because if you get your declaration, then the developer ends up, if you get a declaration, for example, that the title is not affected by the restrictions at all, but effectively the developer acquires a clean title free of the restrictive covenant. And because the process is a Part 8 procedure with very limited disputes of fact, it's often on a question of construction, and it's often based on witness statements without usually the need for oral evidence, the cost is significantly lower than applying for, say, an application to the Upper Tribunal to modify a restrictive covenant, and it's also much lower than contested injunction proceedings. So what sorts of situations might Section 84(2) be useful in? When might it be an appropriate type of case to consider applying for a declaration? There are probably two sorts of situations in which you might think about seeking a Section 84(2) declaration. First, obviously, where there's an issue of interpretation. What does this covenant actually mean? On its proper construction, would it apply to a proposed development? Or second, where there's an issue as to whether the covenant is effective at all, whether it's enforceable, and if so, by whom. As to the first, interpretation and whether it impedes a particular development, you probably need some fairly decent evidence setting out exactly what the development is likely to consist of, what is it proposed to do. So, using Andrew's example, it would be at the point when you had at least some sort of scheme in outline, and if you had planning permission, that would be very helpful. Where there is uncertainty about exactly what you're going to do and whether or not that would the way in which you might proceed with your development would actually conflict with a restrictive covenant, the court can deal with it and has been known to deal with it by, say, granting a declaration subject to undertakings. So in Wellbarn, Shute and Shackleton, which was a 2003 case, there was a covenant not to do anything which might interfere with the exercise of shooting rights. And the court held that, in principle, there was no reason why the development of the land to produce a residential building should per se be incompatible with shooting rights on the land, and granted a declaration that the development could go ahead, but that in the manner of developing, that it would be done in a way which did not interfere with the shooting rights. And that was upheld on appeal. I think the covenantee appealed, saying it was really very, very unhelpful, because how do we know in any given case whether they're going to, in the way that they build, interfere with my shooting rights? And the court said, well, the Court of Appeal thought it was a perfectly sensible way of proceeding, and so it seems development was able to go ahead. The second type of situation in which you might seek a declaration is where, and this is probably, I think it was historically more common, whereas now it's actually often the interpretation variety is more common. But the second type of situation is where there are reasons why the covenant may not be effective or enforceable, and really, the most common sorts of situations which you might see are where there are questions about whether the benefit has been properly annexed to the land. So, can you ascertain what land this is supposed to benefit, for example? But and that can be a horribly, horribly complicated question depending on when the covenant was created. So there are sort of pre-1888 issues and pre-1925 issues, and specific wording might have been required at particular dates and so on. So it is helpful and likely for a developer to seek a declaration if there is genuine doubt about annexation. And the other type of situation where it sort of commonly arises is where the question is whether the benefit was part of a scheme of, say, mutually enforceable restrictions. And there are a number of cases where the question is, was this in fact a proper building scheme? So in Wembley Park estate, which is on the slide, there had been a common vendor which had sold a number of different plots of land, and the purchasers had all entered into identical restrictive covenants in a schedule to the transfer, together with a plan of the property and all the neighbouring properties and so on. And unsurprisingly, it was argued this was a building scheme, but the court held that actually, and by the time it got to court on a Section 84(2) application, the vendor company had gone into liquidation, so none of its plans were available, and there was no information about what it had in fact planned. And the court held that actually there was no evidence as to the vendor's intention, as to what they had intended in terms of the defined area over which the scheme was to operate. So that actually wasn't clear from any of the restrictive covenants, because although they showed the plot being sold and some of surrounding areas, it really wasn't obvious what the total building scheme was meant to be. So a declaration was granted that there was no evidence of laying everything out into lots and what any particular purchaser had been told about the building scheme. And so the court granted a declaration that the applicant's plot was not affected by any restrictive covenants, and very helpfully they were able to go ahead with their development. The jurisdiction is not limited to those sorts of situations, and it can be very useful in a number of novel and quite unique situations. So in Greenwich Healthcare NHS Trust and Quadrant, the applicant, which in that case was an NHS trust, acquired land on which it wished to build a hospital, and to do so it needed to reroute a road which connected the land with a public highway. And in doing so, it was likely to breach some restrictive covenants and also interfere with a number of rights of way and so on. And I think there was no doubt in that case that the restrictive covenants did apply, but it was also the case that the effect of realigning the road was to make the entire road situation much safer and to build a hospital. And so the NHS Trust applied to court for a declaration that in the event anyone sought an injunction, they wouldn't get one, and that they would have to be satisfied with damages. So a really fairly unusual application. Mr. Justice Lightman granted the declaration, holding that while it would usually be inappropriate to grant a declaration about whether a remedy such as an injunction would be granted in future, in that particular case, because of the substantial and obvious public good of realigning the road, and in order to avoid damaging uncertainty about the whole affair, it was sensible to just grant the declaration, and he thought there would be no circumstances in which a judge in future would grant an injunction preventing the realignment. How to apply? The application should be made in accordance with CPR Part 8, because usually there isn't much by way of a dispute of fact. Should state that relief is sought under 84(2), and if any claim is being made, to alter the register. You need some fairly decent witness evidence and support, setting out details of the proposals and so on. The burden of proof is very much on the applicant. And there needs to be really decent evidence of what investigations have been carried out to establish what the likely restrictive covenants are, and why it is that you say that they aren't enforceable. What it is you say about interpretation, and so on. The service can be a fairly complicated aspect of these sorts of applications, because essentially because the declaration, if granted, is against anyone who might have taken the benefit of the covenant even in future. Anyone who has an arguable case to be entitled to enforce the the covenant at this point in time should be given the opportunity to be made a respondent. And so service can be incredibly complicated because although in some cases it'll be obvious who the covenantee is, if, for example, you are applying on the basis that there is no ascertainable land which benefits from the covenant, then it may not be obvious who should be served with the application. So, a procedure has effectively developed whereby what should be done in that sort of situation is to make every effort to give notice to every single person who might possibly have an interest in it. And the way in which you might do that in practice is to literally take out a map and look at all the surrounding properties within a distance, which will obviously depend on what's the appropriate distance will depend on the type of covenant and the type of land and so on. But literally to write to everyone in all of the surrounding properties who might conceivably have the benefit of the covenant, and to send a pre-action circular to all of those people explaining the situation. And in some of the reported cases, the pre-action circular has been sent to anything between 500 to 1,000 different potential respondents in order to satisfy the burden of showing that everyone has been contacted who might conceivably have an interest. And it's generally considered the list should be, it's far better the list is too long than too short. Am I doing on time, Andrew? Am I cutting into
Carry on.
Yes, so even if the application is unopposed, you've got to come to court prepared to argue for the relevant propositions and to explain why it's a proper case for the court to declare. And strategic considerations, which I'll skip through very briefly, I'm sorry. Before making any application, actually one thing worth considering is whether or not the people who arguably might have the benefit of the covenant are even aware of it. Because one thing to bear in mind is that unless you're looking at a building scheme sort of situation, the covenant may only actually form part of the appear on documents within the developer's own title. And so it might be that in the process of asking people whether they object to your proposed development, you make them aware of the covenant which they were previously unaware of. So which is obviously the very last thing you might want to do. So in some cases, particularly if you're dealing with a very, very old covenant, or whether it really is possible that hard to ascertain what the relevant land might be that benefits from it, it might be worth considering simply letting sleeping dogs lie and seeking title indemnity insurance instead. Whether that's going to be possible or ludicrously expensive will of course depend on how on the facts and circumstances. If you are going ahead with the application, then the aim is, of course, to reduce the number of objectors so that you end up ideally with an unopposed application or as few people as possible objecting. And the ways you would go about doing that is having written to everyone and received a few objections back. At that point, it's worth writing again to those who've objected and asking them specifically to state the particulars of the instrument under which they claim that the benefit of the covenants has become vested in them. And I think what you often find in practice is at that point there isn't an instrument killer, and they may not in fact be able to prove that they're objecting really because they just simply don't want development or anything like that, and they may not be able to prove the benefit of the covenant. And also at that point, making them aware of the possibly offering to pay their costs up to that point. So they may have incurred some costs in writing their first letter of objection. They may have sought some legal advice, but also explaining the possible costs, consequences if it did go to a contested application.
So we're now at the situation where Section 84.2 doesn't work for various reasons. It's accepted that there are restrictive covenants that are binding, they are enforceable. The developer may want to go to the Upper Tribunal to get those restrictions modified. And I just want to deal with some basics first of all, because the Upper Tribunal is a fairly niche tribunal. A couple of years ago, I think I was told, Martin Roger told me, there were only about 100 applications a year. So we're not dealing with something that is common or garden. The Upper Tribunal adopts a two-stage process. First of all, does it have jurisdiction? Secondly, should it exercise that jurisdiction? Jurisdiction is established on one of 4 grounds. They're set out on the slide. There is, strictly speaking, a 5th ground. The Supreme Court in Alexander Devine were very keen to say there's a fifth ground that was added in 1969, which is that the restriction impedes the reasonable user and that impeding that user is contrary to the public interest. But generally, that's not going to be particularly relevant to a commercial developer. Now, the other thing to bear in mind is this isn't just freehold restrictions we're talking about. Section 84(1) can apply to leasehold restrictions if you're dealing with a restriction under a long lease or at least 25 years of the lease have expired. So looking at the 4 grounds, firstly, ground A, obsolescence. Important to note, this isn't made out simply because the covenant is old. There must be a change in the character of the neighbourhood, and therefore you're going to need evidence of the planning history. You need to show, for example, that a restriction which was granted in the 1920s benefiting a Victorian villa is now obsolete because the villa has long since been knocked down and a block of flats erected in its place, and a significant number of the other properties around it are also blocks of flats. In those circumstances, you might be able to establish obsolescence, and indeed in HAE developments in the Croft Ealing, where I appeared for the objectors, they were unsuccessful and we came second. It was established that the covenant was obsolete. But don't get fixated on ground A. Ground AA is the most used and the most likely to succeed. That's no practical benefits of substantial value. So what's a practical benefit? Well, it might be a view, it might be prevention of overlooking, it may be preservation of tranquility, it may be because if the covenant is modified, there'll be a green light to other developments. There's no closed list as to what is a practical benefit, but it must be there and it must be of substantial value. Again, there's no fixed tariff as to what the value to be put on this practical benefit might be. But if the reduction in value is greater than 5%, then that may be considered substantial. But you also need to bear in mind that if you're succeeding under ground AA, you're likely to have to pay monetary compensation. This isn't a free modification. You're extinguishing an objector's proprietary rights. You have to pay them compensation. Ground B, as modification is agreed. That's fairly straightforward. Ground C usually follows on from ground AA. The practical benefits are of no value and therefore there's no injury. So if you succeed on ground C, then you've also already succeeded on ground AA. Once you're through that jurisdictional portal, then the tribunal has a discretion. And that's what the Supreme Court decision, the only Supreme Court decision on 100 years of Section 84 in Alexander Devine determined. At that stage, the applicant's conduct becomes relevant because if they have ignored the covenant and built regardless, the Upper Tribunal may take a dim view of that. And a cynical breach will lead the Upper Tribunal to refuse to exercise their discretion. But the recent case of Harrison, Ellis and Hunt shows that a distinction is to be drawn between a cynical breach and carelessness or naivety on the part of the developer. In that case, effectively, domestic developers were held to have been naive and not cynical in starting their building works in the face of opposition from the objectors. But what the court did, or the tribunal did emphasise, was the importance of communications with the objectors and openness. Prior to starting the work, the objectors should have been and were advised that this is what was going to be done, and the options open to them. So that's the basic, the nuts and bolts of Section 84.1. But I want to just go back and look very carefully at the scope of the Upper Tribunal's powers. And as I say, this applies to both freehold and leasehold covenants, but does it also apply to the modification of easements? Let's look carefully at what Section 84.1 says. The Upper Tribunal shall have power from time to time on the application of any person interested in any freehold land affected by any restriction arising under any covenant or otherwise as to the user thereof or the building thereon, by order or partially to discharge or modify any such restriction. And we know what a restriction arising under a covenant is, but what is the meaning of the words or otherwise? And does that mean that actually the Upper Tribunal has a slightly wider jurisdiction that goes beyond merely restricted covenants? And that was the question in Garton and Wheatcroft, the facts of which were these. There was a development plot which included Parcel A. Parcel A was subject to a restriction entered into in 2019, limiting its use as a private garden for domestic recreation only. So Parcel A is the garden of the manor house. Parcel A also benefits from a right of way, a right to use a roadway for all purposes in connection with the use of Parcel A as a private garden for domestic recreation, but not for any other purpose. And planning permission was granted for a new dwelling on the development plot. They weren't going to build the house on Parcel A, but they were going to use Parcel A to provide parking for the new dwelling and as garden for the new dwelling. And that presented two difficulties for the applicant. Firstly, there was the restrictive covenant. They weren't going to be using the Parcel A solely as a garden. They were going to be using it for parking. And secondly, in relation to the right of way. They weren't going to be using the right of way for access to a garden. They were going to be using it as access to parking. So could the Upper Tribunal deal with the right of way restriction as well? And the Upper Tribunal looked at this, and they looked at the wording, and they saw it says or otherwise, and thought, well, maybe that gives us a wider jurisdiction. And then they were referred to the 2011 Law Commission report, which recommended that Section 84, the Section 84 jurisdiction, be extended to cover easements. And they thought, well, hang on a moment, the Law Commission wouldn't propose extending the jurisdiction if that jurisdiction already existed, so that doesn't look right. And then they were referred to the 2005 Court of Appeal case of Hodgkin. And in that case, Lord Justice Mummery said, the Lands Tribunal, as it then was, has no power to vary an easement as such. Well, that seems fairly clear. However, in Hodgkin, the Court of Appeal did effectively vary an easement. There was similar factual nexus. There was a right of way for all purposes in connection with the use of a property. That property itself was subject to a restrictive covenant requiring it to be used as offices. The tribunal modified the restrictive covenant so as to permit the property to be used as holiday lettings. And the Court of Appeal said, as a matter of construction, that means the right of way could be used for holiday lettings. The point being that the right of way was for all purposes in connection with the use of the property, The use of the property had now been expanded to include holiday lettings. Therefore, as a matter of construction of the right-of-way, there's nothing to prevent you using it as modified. So the facts of Hodgkin rather set against the clear judgment of Lord Justice Mummery. Then there was also the 2023 decision of His Honour Judge Monty, who said, looking at the Law Commission paper, that it was plain that the tribunal had no jurisdiction under Section 84. So what did the tribunal do in Garton? Well, perhaps unsurprisingly, they decided they had no jurisdiction to modify the easement. They considered that Hodgkin was simply concerned with the construction of the terms of the right-of-way, and there hadn't in that case been any modification of the right-of-way, which, when you look at the facts, is a little difficult to rationalise. So we're left with a situation where we still don't know what "or otherwise" means. I thought maybe it referred to rent charges. That might be another means to avoid the words being pure surplusage. But rent charges have their own separate statutory modification procedure. So it's plain that short of the Court of Appeal, you're not going to get the tribunal to modify an easement, but there is still, it seems to me, some sort of argument. The final point to note from Garton is that the tribunal then went on to consider the modification of the restrictive covenant. And you'll remember that restrictive covenant was to use as a garden. And they determined that they had no jurisdiction to modify that covenant under ground AA. They held that there were practical benefits of substantial value to the owners of the roadway, in that the owners of the roadway had freedom from potential litigation as to unlawful parking on the roadway. And it seems to me that that is a fairly liberal reading of practical benefits, and a fairly generous construction of them having substantial value. But as I say, it didn't make any difference because they weren't modifying the right of way. So to conclude, points to note: tribunal has a two-stage process in respect of applications to modify. Firstly, jurisdiction. Secondly, discretion. And you're going to fall foul of the discretion if there's been a cynical breach. Tribunal won't expand the scope of right-of-way pursuant to Section 84, but depending on the wording of the right-of-way, you might be able to get round that. And finally, take care to ensure that the proposed use of a right-of-way is not excessive. Thank you very much indeed.
Well, thank you, Andrew and Lara, for that fascinating talk. One of the things that I've taken away from that is that the tribunal's made it very clear that it isn't always easier to ask for forgiveness rather than permission. So we must be telling our clients that from now on. Now, we're going to have a short break. We're going to have some tea, coffee, and some biscuits. I did try to get cake, but I'm afraid it's just not available. But afterwards, we're going to come back and talk about insolvency and imposters, where we'll talk a bit about what happens if your development falls into insolvency and what happens if you get some unwelcome visitors and getting newcomer injunctions. And then in that final session that I mentioned earlier on, we're going to be having that panel discussion about what a good regeneration looks like. And I might even be able to promise you a bit of chat on the BSA. So please do join us again in about 30 minutes.